Okay, we are live. Thank you all for being here. This is webinar number 6, Racism and the Death Penalty. I'm Nancy Haight, the Executive Director of Death Penalty Focus. For those viewers who are new to us, Death Penalty Focus is a nonprofit organization formed more than 30 years ago to end the death penalty. With ballot initiatives in 2012 and 2016, Death Penalty Focus urged Californians to join the rest of the Western world and abolish the death penalty. That was not successful, but now the political horizons in California are looking favorably on the movement for racial justice and in support of Black Lives Matter. Abolishing the death penalty is essential to any future racial justice movement. Briefly, Death Penalty Focus is a nonprofit organization. We have the opportunity to work to abolish the death penalty because of your contributions. So throughout this program, you can text END executions, END-EXECUTIONS to 56512. To join us, follow through. We won't be answering questions or recognizing hands raised during the speaker's presentations. So please enter your questions in the Q&A box. We'll collect them and have 30 minutes after the presentations that are dedicated to answering your questions. It is my great pleasure to introduce you to Sister Helen Prejean. Sister Helen is an activist, humanitarian, author of Dead Man Walking and River of Fire. Sister Helen's work in the ministry against the death penalty has changed people's lives and changed people's minds about the death penalty. So thank you for being here, Sister Helen. It is an honor to introduce you to Brendon Woods, the public defender for Alameda County, California. Brendon is a criminal defense attorney, a racial justice activist, former president of the California Public Defenders Association. I first came to know Brendon last March when we lobbied in Sacramento for the California Racial Justice Act. The Racial Justice Act was just signed into law last week by Governor Newsom. Congratulations, Brendon. Last, I'd like you to introduce you to my most esteemed colleague, Mike Radelet. Mike is a professor in sociology, criminology, and capital punishment at the University of Colorado in Boulder. He's an expert in racism in the criminal justice system and racism in capital punishment. He has testified before judges, juries, and legislators. His testimony was key to the repeal of the death penalty in Colorado. Thank you for being here, Mike. With that, I'd like to introduce you, to start off this session about race and the death penalty, I'd like to introduce you to a case that illustrates the worst of the worst justice, racism in action at every turn. Here's the story of Tennessee death penalty inmate Prejean. Let me just share my screen here.
You know how it is when you got your first child. First child is very important. Prejean, he was born premature. And we had great plans for him because he was the oldest one. And we thought for a while he was going to be the only child that we had.
My brother Prejean is scheduled to die this year, December the 3rd, for a crime he did not commit. DNA testing could prove his innocence. My brother is living with an intellectual disability, and it is unconstitutional to execute a person with an intellectual disability. I call him Bubba. I tell Bubba, I said, Bubba, you were convicted as soon as they saw you because of the color of your skin. I will continue for the rest of my life, as long as it takes, to fight for my brother's freedom. And it's not too late to save his life.
That is the beginning of the story of Prejean. Second here. Prejean, oops, sorry about that. Sorry. Sorry. Sorry about that. There's always technical difficulties here. Let's see. A little bit about Purvis Payne. Purvis Payne was 20 years old in June 1987. He was the son of a preacher and a child care worker. He had a good family. He was a good kid. He never got in trouble. He was never violent. On a hot summer day in Millington, Tennessee, which is Shelby County, Purvis was hanging out with his friends. He decided to visit his girlfriend, but she wasn't home, and across the hall he heard distressing sounds. Purvis went in and found Cherise Christopher, her daughter and son, brutally stabbed. At first, Purvis tried to help Miss Christopher. Then he stopped and he panicked, and he knew that he, as a Black man, would be a suspect. He ran down the street, was arrested, and the rest is history. The officers at the scene never considered any other suspect. They destroyed any evidence that could be used to exonerate Purvis. At the trial, the prosecutor, with absolutely no evidence, portrayed Purvis as a drug-crazed super predator. The jury convicted Purvis and sentenced him to death. Now, 32 years later, the Innocence Project and Kelly Henry from the Federal Defenders discovered hidden evidence that was never tested. In their motion to test the evidence, his lawyers said that case was concocted out of whole cloth and based on outdated stereotypes. Let's see. Okay, bear with me so I can see if I can share this with you. All right, this one has vanished. This one has vanished. Let me just tell you a little bit more about the story. Hold on. There we go. A little bit more about the story. Some evidence was discovered. It had been vanished and disappeared. And the Innocence Project and Kelly Henry pulled this evidence together, filed some motions, and finally got the judge to agree to look at the DNA evidence. Purvis Payne is still on death row. He's had tremendous support for more hearings so that he can prove his innocence. As of Monday, his lawyers had filed clemency petitions so that he won't be executed based on the idea that he does have intellectual disability. With that, sorry here. And Shelby County is a very terrible county, and Sister Helen, I'm sure, can speak to you of that. And there are more people from Shelby County on death row in Tennessee than from any other county. Shelby County has a long, long history of lynchings. They have the most lynchings, the history of the most lynchings anywhere in the United States. So definitely Shelby County let down Purvis Payne, but the country also let down Purvis Payne. I just have to show you in 1991, when he was arrested, tried, sentenced, and put to death, a number of really bad things were happening in the country. So let me just try and share this one story with you. Sorry, that is not. Sorry, I'm having difficulty with all of these videos, so please forgive me. The story that I was going to show you was the story of Ted Koppel on ABC Evening News, delivering the message that the Supreme Court had decided that victim evidence was completely permissible. And the story that he showed was Purvis Payne's story. Of course, Purvis Payne is a Black man, and the victims were white victims. And the family of the victims got up and told the jury tremendous long sad stories of who they were going to be missing, as though Purvis Payne's life wasn't equal. The second story that Koppel told was a story about the US Supreme Court agreeing that a life sentence was appropriate for selling a pound of cocaine. So with that background, first of all, we have to say we're looking forward to good news from Purvis Payne as far as clemency goes, and we certainly hope, that he will be able to be exonerated. So with that, let's start our conversation about race and the death penalty. So Mike, would you like to start?
Sure. It's a real honor to be on a program for Death Penalty Focus. I remember in October of 1989, being on the inaugural march against the death penalty for Death Penalty Focus. We started in Sacramento on the way to San Quentin. I got as far as Oakland and had to go back. At that time I was teaching at the University of Florida. And the day after I left was the earthquake in October '89 in San Francisco. And so the motto, Death Penalty Focus, is shaking things up. And indeed they have over the years. I want to just set the stage here a little bit for some stuff on about history of the death penalty. This is the 2-minute version. It will be on the exam. The federal government started to collect data on executions in the United States in 1930. And we know that between 1930 and 1967, there were 3,859 people executed in the United States, 3,859. And 54% of them were African American. The racial imbalance was especially evident for executions for rape. There, 455 people were executed for rape during that same time period, and 405 of them, 89.5%, were Black men, almost all of whom had white victims. That was one of the reasons that there was so much concern raised about the death penalty. The NAACP Legal Defense got involved, and that led to the 1972 case of Furman versus Georgia, in which all death penalty statutes were then invalidated. So we talk about the modern age of the death penalty as beginning after 1972, when the states went back to write new death penalty statutes. So this morning I was looking at the proportion of people who were on death row and their races. Now, one thing that's changed is instead of the world being black and white, we also count other ethnicities and races, Asian, Native American, Hispanic. But we find, so that we've got better data, but we find that right now on death row in the United States, 58% of the people are non-white. They're either African American, Hispanic, Native American, or Asian. That means that before 1972, 54% of those executed were African American. Now we have 58% of the relevant population are people of color. So we haven't really gotten very far. You talked about Purvis Payne. The case that I wanted to highlight is one that Sister Helen will remember, though she doesn't know that I'm going to talk about it. It's a case from Bartow, Florida. And I did a little study down there of race and death sentencing. Helen, this is the old 14-inch wide computer paper. I ran this in 1983, and the name on it, J.J. Tefero. Again, 1983. In May of 1990, Sister Helen was visiting me in Florida. We were sitting on the couch when Jesse Tefero burned to death in the electric chair. We were there with his mom. It was not, unbelievably bad time. This the little study that I did showed widespread race of victim, race of defendant discrimination in the judicial circuit, headquartered in Bartow, Florida. Bartow is not where you go when you go to Florida on spring break. It's about 100 miles southeast of Tampa. In any event, I went down to testify at the penalty phase for a man named Tony Peek, P-E-E-K. He had been sentenced to death, granted a new trial And I was asked to testify at the penalty phase about these race statistics. And I walked into the courtroom, and the judge appeared in front of the jury and said, "Hi, I'm Judge Smith. Judge Jones cannot continue with the penalty phase for reasons that don't concern you. And so I'm going to take over for the penalty phase." So we proceeded. The judge immediately said that my little study was not relevant and that I couldn't testify. I was on my way back to Gainesville, and Mr. Peak was quickly resentenced to death. Then in 1986, 2 years thereafter, the Florida Supreme Court ruled in Mr. Peak's case. Again, they threw out this second death sentence. And at the end of the decision, the Florida Supreme Court wrote, "By the way, because of our decision on what some people will call technicality, they don't want to discuss the other issues raised in the case, but they said for one exception, for future guidance at the bench, we want to address the circumstances requiring the original trial judge in this case to disqualify himself after the completion of the guilt phase of the trial. The disqualification resulted from comments made by the trial judge immediately after appellant was convicted, and they were discussing procedures for the penalty phase. The defense attorney stated that the judge says, quote, since the N," the Florida Supreme Court printed it in their decision anyhow, "since the N mom and dad are here anyway, let's go ahead into the penalty phase right away so we won't have to subpoena them back to cost to the state." Another person heard the comment as, quote, "since the N word are here, maybe we can go ahead with the sentencing phase." And then here's what the Florida Supreme Court says about it. They say trial courses not only must be impartial in their own minds, but also must convey the image of impartiality to the parties in the public. Judges must make sure that their statements both on and off the bench are proper and do not convey an image of impartiality. This type of conduct is required of our judiciary, blah, blah, blah. So they're not really worried about the judge being a bigot. They're worried about that image of impartiality. Mr. Peak got a new trial, not for the race reasons, but for the other issues that were raised in his appeal. He came back to Tampa in 1987 for the third trial, and there we have it. Convicted rapist, exonerated of 1977 rape and murder charges. He's exonerated. He's one of the now 171 people who's left death row because of innocence, including, I might say, 5 people who have been released from death rows this year because of finding of innocence. So California is, of course, ripe for race studies. Glenn Pierce and I did a study in Santa Clara Law Review that was published, I don't know when, 2006 or something like that. We found that in California, we looked at every homicide in the 1990s. The sample was something like 33,000 homicides. And we concluded that those who kill blacks were 59% less likely to be sentenced to death than those who kill whites. Those who kill Hispanics, 67% less likely to get the death penalty than those who kill whites. And that was controlling for aggravating factors in the case. We had a couple of control variables. That study was used by the California Commission on Criminal Justice, but to my knowledge, I don't think any court has ruled on it because statistics like that in almost all jurisdictions in the United States were ruled inadmissible in the 1987 case of McCluskey versus Kemp. McCluskey. Now, the California legislature, in its wisdom, and your governor just last week, made a remarkable showing of support or acknowledgement of the problem that California, at least, has got with race by signing the Racial Justice Act. And Mr. Woods will be talking about that. Okay.
Thanks, Brendon. Yes, would you please tell us about this?
Yes, if I can figure out how to unmute, yes, I'm happy to. So let me start off by saying thank you. I am completely honored to be on this panel, and I'm going to say I have no shame. I'm a fanboy of Michael and Helen. This is great. I'm going to completely geek out over this conversation. So I'm also going to start by picking up where Michael left off. when he talked about McCluskey versus Kemp. So I went to law school to be a public defender. I went to law school to fight against racism in our courts. I went to law school because Black and brown people are treated a certain way. And during my beginning of second year in law school, I was fortunate enough to hear Bryan Stevenson speak. And this was before he was Bryan Stevenson book and movie Bryan Stevenson. He was like, great Bryan Stevenson, but not like amazing, phenomenal, off the charts Bryan Stevenson. So I heard him speak. And I was a second year law student, all bright-eyed and bushy-tailed. And he talked about McCluskey versus Kemp. And when I heard that, in my mind, I was like, this is some straight bull. I'm not going to say the rest, sister. I'm going to be polite and respectful here, but straight bull. And I left that talk and immediately went to Lexis and looked up that case. And I read it. And it was crystal. It was salient. It was everything that is wrong with America and our criminal punishment system. It was a look at our country's racist past, present, and future. It is race on display for anyone to see. And so I'm going to, just bear with me, just go over the facts briefly about McCluskey, because I don't think we discussed it enough. Warren McCluskey, despite his name, Warren and McCluskey, he was a Black man, okay? He was convicted of 2 counts of robbery and 1 count of murder in Georgia. And the person he was convicted of murdering was white. And so McCluskey and 3 of his buddies robbed a furniture store. They went in, they were all armed. They entered the store, they rounded up the customers, had them laid on the ground, and a silent alarm was triggered. And because of that silent alarm, a police officer came to the door and walked in. 2 shots were fired. The police officer was killed. McCluskey himself was arrested a few weeks later, and he confessed to the robbery, but he denied that he ever shot the police officer. The case was made against him because of one of the bullets that struck the police officer was a .38 from a .38 gun, and witnesses said that they believed McCluskey had a .38 revolver. And there were also 2 witnesses that said they heard McCluskey later on admit to the shooting. And that was it. That's all the evidence they had against him. And so when we talk about McCluskey, we actually never really discussed the fact that the person that was shot was a white police officer. Now, I don't think that would have changed the outcome of the case, but it absolutely made it certain that there would not be a different outcome by the fact that there was a white police officer involved in that case. So as we all know, in that case, they did the Boulder study, and they looked at over 2,000 murder cases that occurred in Georgia during the 1970s. And they sought to overturn McCluskey's conviction based on the way the death penalty was implemented in Georgia, due to its racially disproportionate impact, saying it violated equal protection and the 8th Amendment. And you have to look at that study, and the statistics from that study are off the charts. So in that case, like similar to some of the studies Mike was talking about now, the death penalty was assessed in 22% of the cases involving a Black defendant when the victim was white. It was assessed in 3% of the cases involving a white defendant and Black victim. The death penalty was assessed in 1% of the cases involving a Black defendant and Black victim. That's off the charts. Now, what was even more striking to me, and more starking and more egregious, is that that study also found that prosecutors sought the death penalty, went after the death penalty in 70% of the cases involving a Black defendant and white victim. 19% of the cases involving a white defendant and Black victim, and only 15% of the cases involving a Black defendant and Black victim. So think about that. 70% of the cases with a Black defendant and white victim, the prosecutors sought the death penalty. So in that case, as we know, with a 5-4 ruling, Justice Powell, who wrote the decision, said that the study was valid. It was not in dispute, but it was insufficient to show a constitutional violation. Instead, they required that the defendant show exceptionally clear proof of discrimination, and that the person involved, the petitioner, the actor, the decision maker in that case, acted with a discriminatory purpose. In that case, Justice Powell said that such apparent disparities in sentencing are an inevitable part of our criminal justice system. And that was the line that stuck with me and probably stuck with most people. But that's the Supreme Court of the United States saying in 1987 that the way a death penalty is implemented is racist and there's not a damn thing they're going to do about it. So here I am, as a black man, reading this and saying, this is personal. This is the Supreme Court saying that if a black person kills a white person, we as a state will kill you. We will put the money, efforts, and resources into killing you. But if a white person kills a black person, we're going to give you a pass. We're going to give you a pass. I have never, ever, probably legally, seen a more compelling argument for the statement Black Lives Matter than the case of McCleskey. It's been so often referred to as the Dred Scott of our generation. So that brings me to the honor and I guess the pleasure of being able to talk about AB 2542, the Racial Justice Act, that was authored by Assemblymember Ash Colliver. And I have to say for the record, Ash Colliver, former public defender, we started at the same time together, and I do believe that laws like this get created by people who have seen the system and how it works and how it impacts the people we care about. And there are lots of other people who were involved in this bill who get credit. Ella Baker Center was amazing. Amber Rose Howard from CURB, Natasha Minka, so many people were involved in this. And what AB 2542 is, it's a head-on assault, a head-on attack on McCleskey versus Kemp, and it's an attack on systemic racism, systemic and overt racism in the criminal legal system. So specifically, the bill makes it possible for a person charged or convicted of a crime to challenge racial-based bias in their case. It can be racial bias that's shown by an attorney, judge, law enforcement, or expert witness, or a juror involved in the case. It can be around racial discriminatory language in the case, in the court proceedings. It could be racial bias in jury selection. It can look at statistics, statistical disparities in charging and convictions, disparities in charging and sentencing. That is now able to be used and I guess valid. The court's saying, we are in California now saying it's valid. And some of the remedies that this bill provides for is that you can reseat a juror by peremptory challenge. You can declare a mistrial. You can discharge a jury panel and bring in a new panel. You can reduce one or more of the charges. And this bill also says that monetary sanctions and training alone are not sufficient enough as a remedy. Remedies around post-conviction. The court finds that if a conviction was sought due to race, they can find that conviction and sentencing invalid and order new proceedings. And so it's an amazing case, amazing law, I should say. And what it does at the end, I think, really is gut McCleskey, because once the defendant or defender shows a prima facie showing of racial bias, the standard now is substantial evidence, as opposed to what McCleskey said was exceptionally clear proof that the person acted in a discriminatory purpose. So it's great to be in California. It's great to have people who are pushing these laws. And I'll back up. When Nancy, you heard me talk at the press rally in March, I thought the Racial Justice Act was amazing. And I'm like, there's no way in hell this is ever going to get passed. No way in hell. And here we are. It's passed. And it's really a great day in California. I'm happy to discuss more. I know I went on a little bit long, but thank you.
Oh, that's great, though. That's great. When I listen to all this, when I listen to your statistics, Brendon, when I listen to Mike, it's not even a subtext. What the law does is devalue the lives of people who are not white. They are treated as much less than, and it is a scourge in our system. So, Sister Helen? You're on mute.
It is really great to be part of this and look at the time and history in which we're living now. And I just want to bring out, I'm going to tell basically the story. It's in Death of Innocence of Dobie Gillis Williams. And just to say, I came into this, all while Tim Robbins is doing the movie of Dead Man Walking, he kept saying the nun is in over her head. And the nun was in over her head. I knew nothing when I wrote A Man on Death Row. Then I'm at his execution. I know about the criminal justice system. First teacher, Millard Farmer. And Millard Farmer took on the appeals case, tried to save Pat Saunier's life. And while we drive into the prison, he's teaching me. And one of the things he taught me was that that race you don't see right away if you just look on death row. It's overwhelming who the victim was and if the victim was white and who's outraged at the death, and just what you're saying, Nancy, and the death of many citizens didn't seem to count. That if you kill a black person, if the life's negligible, the death is negligible. First thing he taught me. And the second thing he taught me was that why did you have Furman in 1974 and 72, and just 4 years later, the death penalty's put back? What happened? And he said, what it was the southern states reacting to Furman, and you're taking away the death penalty from us. All the statistics clearly show the executioners have been the 10 southern states that practice slavery. And it was backlash that then on the Supreme Court, and they put the death penalty back. Dobie Gillis Williams, black man, IQ 65. I take his case. I sound like a daggone lawyer. I took him on to accompany him spiritually and to befriend him and to be there for him and to fight for everything he needed, if he needed a lawyer, whatever. And he didn't have a chance. A little town, Manny, Louisiana, white woman killed in her bathroom. He was pulled up in a dragnet of young black men. He was questioned all night, alone, without a lawyer. Trial, quick trial, sentenced to death, all white jury, par for the case. And at his funeral, afterwards, I'm with his mama, and she says to me, Sister Helen, nobody ever heard Dobie's voice. The prosecutors were the ones that talked to the media. You got to tell his story, and so people can hear his voice. And that's why I wrote about Dobie Gillis Williams in Dead Man Walking. And of course, it was just classic. He had a lawyer, intimidated, cowed, who let an all-white jury be sat. And then even when he got a break from a federal district judge, the Fifth Circuit overturned it and just said that when that white jury was sat, his lawyer did not raise formal objections. And I began to learn how the law works and how if you don't have a good defendant by your side, you can get sentenced to death and you can be killed. In appeals courts, with their desire for, what do they call it? Not closure, but the equivalent of, we got to close these cases with procedural, what's it called?
Finality.
Finality. Block evidence and let you be killed. Dobie's case just really exemplifies it. I want to tell you what I'm doing now is like I'm taking the book, and with different classes, I just did this at Kuka College under a writing class where the writing students took Dobie's story and just the art of writing persuasively on a controversial case. So it was through the writing lens that we took Dobie's case. So I'm fresh with it right now. In the courthouse where Dobie's appeal happened, it was Colfax County. And there's a memorial plaque. I looked at it, and it's the memorial plaque to 3 white men who died in putting down a race riot where they killed 150 black, newly freed slaves, and the memorials to the 3 white men. And then the case went to the court. There were all kind of a white mob was involved in slaughtering black people, setting the courthouse on fire where they had taken possession and killed them, slaughtered them. And it makes its way into a trial where 3 of the defendants were found guilty of violating the civil rights of fellow citizens. And the key thing that happened here was that it went up to the Supreme Court in U.S. versus Cruikshank. And in that decision, the Supreme Court said that you could not, that the 14th Amendment applied only to federal government acting against state powers that violated the rights, but not private citizens. And that has emboldened white supremacy to this day. And you look at the cases of white supremacists going into the protest marches against George Floyd, and you just see the bias in the courts, the bias in the law. And that's the big thing I've learned. I thought we had the best court system in the world. And I thought if you could just get your day in court, and where it's all flawed and cracked and faulted from the beginning is what, Greg, the criteria that the Supreme Court set up in Greg, that you're only supposed to pull out the worst of the worst, either by the nature of their crime or their character, and that we have a way to do that. We have a way to pull out the worst of the worst. And where it will never work is because it's left up to the prosecution's discretion to go for death or not. And we just recently had Will Barr resuming federal executions because he can, because he has the power to do that. And if you don't have a prosecutor seeking death, you don't have a death sentence. So you get in a culture, a racist culture, with the long black dark shadow of slavery behind it, like our 10 southern states, like my state, Louisiana, like Georgia, like Tennessee. And then you give discretion up to a prosecutor to seek death or not. They're influenced by culture because you got a criteria that doesn't work, and it never did work. And it's been faulty from the beginning. So race, as we're learning, systemic racism, that Cruikshank decision it kind of legitimized private citizens, especially white. It's legitimized white supremacy. And we're finding out that's in every aspect of life, of where you buy a house and what role the law and government has played in discrimination in housing and everything. So it is a great time to be alive. And I am so proud of Death Penalty Focus. I've been with you every chance I got. Brendon, great to hear your being in there. And this is truly a significant moment. And so thank you.
What strikes me as we all speak about this is the fact, and Brendon, I'm sure that being a trial lawyer, this is so obvious to you. But when you go to court, the prosecutors are primarily white people. The judges are primarily white people. The court staff are primarily white people. I have never been in an appellate court where there was a black justice. And all the way through the courts of appeals in the states, they're predominantly white people. And it makes a huge difference. The idea that black people are less than is just an undercurrent through everything in the justice system.
Can I say this to Nancy? The way that the justices, Supreme Court justices, interpret text, you bring your experience to text. There's no neutral text. And Thurgood Marshall said this. The first African-American on the Supreme Court said, when I read equal justice under law, and a privileged white person who, went to an elitist school, reads the words equal justice under law, our life experience helps or determines us in the way we interpret text. It's true of the Constitution. It's also true of the Bible when we see how people selectively quote biblical text as well. I just want to throw that in.
Thank you. Thank you for that. A question and an experience that I've certainly had picking juries is the whole process of jury selection and how jury selection for Black defendants is completely biased. And I'd like to ask you, Brendon, about your experience with that.
Sure. And I want to go back to just to something you said about the need for diversity with prosecutors. And I think it runs, the issue's bigger than that. It's the way our criminal punishment system at its core is systemically racist and does its job of dehumanizing people, dehumanizing Black and brown people. And I think if you are on that side, unfortunately, too often as a prosecutor or even as a judge, the act of incarcerating people, putting them in cages, exacting punishment over and over and over again, you see the people you are doing that to as less than human. You don't see them as human, and that's the only way you can probably continue to justify exacting that harm, pain, and violence in those communities. So yes, more diversity, but also realizing that what they are doing, the actions they are taking, is happening to people, not defendants or inmates or prisoners, but people who have families and brothers and sisters and come from communities. So that's one piece I think is always missing, and we have to discuss, and that needs to be shared across all races, if that makes sense. Now with jury selection, I think that's one of the biggest issues we have with regards to relating to people, having people relate to our defendants. Clearly, the better or more diverse a jury is, the better the outcomes are for the case. Juries that are diverse deliberate longer, they're able to view evidence better, and they consider our clients in a better light, as opposed to coming in with maybe some implicit racist attitudes that the other people might have. Two things recently that we've been able to do around that, two laws that have been passed in successive years, or three laws now. Last year, we were able to pass SB 310, which gave people with prior felony convictions the right to sit as jurors in California, which is absolutely tremendous. Prior to that, over 33% of Black men in California could not serve as jurors because of their prior felony conviction. So talk about some sort of inherent systemic discrimination right there. That's it on its face. And then this year, we were able to get AB 3070 passed by Shirley Weber, which is a direct attack or confront or fix of the Batson and Wheeler process. Right now, as you know, if a prosecutor kicks someone off the jury who is Black, they can give almost any reason to do that, as long as it's quote unquote racially neutral. And they give reasons such as the person lives in this neighborhood, or the person has been to jail to visit a family member, or the person does not trust police officers, or the person, I don't know, supports Black Lives Matter. Those are all reasons that prosecutors give to strike Black people from juries or people of color. And now, because of AB 3070, those reasons will be presumptively invalid. So that law, I think, will have a tremendous impact with regards to our juries, how diverse they are, and having our clients, who are predominantly Black and brown, actually have a jury of their peers.
I thought it was actually quite hypocritical in the debates about AB 3070, the Jury Selection Act, that the prosecutors all ganged in and said, this is going to cause so much work for us. You know, we have to find this race neutral reason. And if they were doing their jobs, they would have the answer to what is your race neutral reason. It was so hypocritical.
So just going back to AB 3070 and 2542, the Racial Justice Act, they won't create more work for prosecutors if they're not racist. I mean,
Exactly.
Good, let them work harder if they're racist. That's good. Put them to work.
Exactly. What do you have something to add to this, Mike?
I was going to make 3 points. One is data on executing white people for killing Blacks. I did a study 30 years ago. I went through 16,000 records of executions in the United States, and there were only 30 cases where a white person had been executed for killing a Black. And even in those 30 cases, it was something like, in 10 of the cases, the white guy was executed for killing a slave. And you think, well, you know, what's going on here? Why is a white guy executed for killing a slave? And I went back and got contemporaneous newspaper reports, and nobody cared about the family of the victim. What they cared about was that slaves were expensive. And if you kill a slave, you know, then it cost a lot of money to replace her or him. So it's cases like, you know, white guy gets pissed at his white neighbor, goes over nobody's home, so he kills his slave, and it's treated like trashing your car. You know, it's an economic crime. Second thing I want to point out is that Brendon had mentioned the McCleskey case, which is why we need the Racial Justice Act. That McCleskey case was written by Lewis Powell, Justice Powell, and a couple of years later he had retired, and there was a biography done by the dean of the law school of the University of Virginia, Dean Jeffries, And Jeffries quoted Powell. He asked Powell, if you had it to do over again, are there any cases that you change? And he said, yeah, McCluskey was the worst decision he ever wrote. That was a 5-4 vote with Powell in the majority. And so, in those days, we came just an inch away from, if not abolishing the death penalty, requiring more racial equity in the way that it was applied. Brendon also mentioned Just Mercy and Brian Stevenson. And I have to tell a story Helen will remember. A few years ago, Helen was speaking at the University of San Francisco Law School. And I was in the audience. And like all these nuns, she kept calling on me to ask questions that I didn't know the answer to. And one of them was, I wanted to mention Just Mercy. And I've known Brian since he was in law school. And I read the book. I had used it in my class. But I froze. I couldn't remember the name of the book. And a law student came up. And remember this, Helen? She had Just Mercy tattooed on her forearm. Well, she's never going to forget that. And the final thing that I want to say about this Racial Justice Act, when McCluskey came down in 1987, the first race study that I did was in 1979. And it was so disheartening and so disappointing that basically nobody even cared about these statistical studies. But it really is a lesson that you just keep on trucking and you keep doing this stuff. Laura and I have published some stuff on juries and how the non-unanimous jury service. And I don't know how many race studies I've done, 25 or 30. We're gearing up to do another one in California. I've got a meeting on that on Friday. We're designing a study, so we're going to go after that Racial Justice Act. And it's a real lesson to students. Just keep on trucking, and there's no easy route to abolishing the death penalty or fighting other injustices. And along the way, you get smacked down, and it seems you're all alone and nobody's listening. But this Racial Justice Act in California has really taught me that if you work at it long enough, the truth will live on.
Well, I would like some conversation about the non-unanimous jury and how that is just based completely in racial discrimination.
Laura, do you want? Okay,
Go ahead.
I'll start. So in Florida, where I spent
Are you frozen, Mike?
Yeah, he's
20 years, I have this massive data set of every. I'm a who?
You're frozen.
Oh, it's cold in Colorado. We don't have those fires like you got in California to warm us up. So can you hear me now?
Yes,
Yeah.
yes.
So Florida was the first state to pass a post-Furman death penalty statute. Furman came down June 30th, 1972. The new Florida statute was signed into law December 10th, 1972. And nobody knew what they were doing. The House of Representatives passed a bill saying that the jury had to be unanimous, and the Senate passed a bill saying that a 3-judge panel would be the one to determine life or death. And they said, in the middle of the night, right after Thanksgiving in 1972, the legislator says, well, hell, we'll make the jury vote a recommendation, and the judge can take it or leave it. So now in Florida, or then, you needed not only, for death sentence, you didn't even need a majority jury. As a matter of fact, in Florida, there have been 166 cases where the jury have voted life and the judge could override it and give them death. That was also possible in Alabama, Delaware, and one other state. And there's still people on death row, I know, in Alabama and Florida, whose death qualified juries, the first question they ask you when you go in to serve on a death penalty jury is whether or not you support the death penalty. And if you say no, they thank you and send you home. They want people who, kind of foam at the mouth and say, I want to kill. You got to be pro-death penalty to sit on a jury. But even when that pro-death penalty jury voted life, there were 166 cases where the judge rejected the jury and imposed death. 4 of those guys were executed. So, you know, juries count. And even today in Florida, they don't require a unanimous jury rec. And there's been a lot of litigation about that. Laura's been right in the middle of it.
A question that comes to my mind in looking particularly at a case like Prejean is the question of innocence. I mean, I think that we know that 173 people have been fully exonerated who had been on death row, and a huge percentage of those are Black. And it really speaks to the inherent race in the system and the fact that Black defendants are treated differently than white defendants.
Well, one of the reasons why, and this is because of the case Payne versus Tennessee, before that, a couple years before that, the Supreme Court said that families of homicide victims could not testify to juries about the impact of the homicide. You know, fair enough, you want the juries to react only to legally relevant stuff. But in Payne versus Tennessee, it's about 1990, the Supreme Court said, no, that decision was wrong. We will allow victim impact testimony. So when families come in and they cry and do, you know, as well they should, the juries seem to be more sympathetic to families of white victims than families of Black victims. And that adds to the racial disparity in death sentencing, because the families are able now, under Payne versus Tennessee, to talk about the impact of the murder on their lives.
Well, and also the fact that the jurors are primarily white, you know, perhaps they relate in a different way to Black families than to white families.
Mm-hmm.
I mean, Sister Helen, do you have a comment about that?
Yeah, you know, when I wrote Debbie Walken, I wrote about that. It's just such a human thing that we tend to identify people that look like us, sound like us. It's just a deeply human thing. But when you put it in a criminal justice system where you're deciding somebody's life, and there's just not this neutral thing of, well, I'm white and they like me, but they're Black and they're not like me. It is a bias riddled with fear and all of that makes us afraid of people. We are afraid of people. And I mean, what we're doing here, getting a hold of this, coming to understand this is what we got to do with the public. It's people like my job, Mike's job, our job, to get to the people, to educate the people. And when Mike says, keep on trucking, may I just say, it took 1,600 years of dialogue with the Catholic Church to finally get a position. No, we cannot give the state the right to execute under no circumstances. Can we give governments the power to kill? It's, folks, that's 1,600 years of dialogue. That's a heck of a long dialogue. But here's what I found out, that you give the people a chance, and Thurgood Marshall said this from the very beginning, that people say they support the death penalty, educate them, bring them close to it, and people will get it and they will not support it. And that's the job of us that do public education, or the journalists, the writers, the people out there with the people. And some of our best educators are you, the lawyers, coming right out of the fire of your direct experience and giving it to the people. And people like Mike, 16,000 cases he looks at and does that study and then gets that knowledge to the people. Onward, onward.
And Helen, you should mention that the 1,600-year fight for the Catholic Church to recognize the immorality of the death penalty ended last week when Pope Francis, I call him Pope Frank, we're like that. But Pope Francis—
You need to be close to the Pope. You need to be close.
Yeah. Anyhow, there's an encyclical that he signed off on that made it clear, no ifs, ands, or buts. And I know, Helen, you've been in all sorts of circumstances back in the olden days where priests and other clerics in the Catholic Church have said, oh no, the Catholic Church supports the death penalty, but only for the worst of the worst. But so it's really just in the last 30 years that the Catholic Church has come around. And I think the most important reason is the impact of that book, Dead Man Walking.
Well, and
There you go.
along the way, in talking with the people, I did bump into two popes, and I got to have direct dialogue with two popes. So it's nice to be able to have the dialogue with the top guy when you have a chance, but it's you don't talk to him any different than you're talking to the people.
Right.
And it's just a lot to do with culture, a lot to do. It's not just Catholics, Christian churches. I mean, y'all, we got to get religion and we got to get Jesus right, because look at what the Trump administration and Will Barr and these people are doing and using religion. And Jeff Sessions quoting Romans 13 to justify separating children from their parents at the border. He quotes the Bible because a civil authority has the authority of God behind. So these people are breaking the law by crossing the border illegally. It's on them that their children have been taken, and they quote the Bible. I mean, we got a lot of work with religion to do. People like me.
It's quite a problem too, as far as the Catholics go. 62% of Catholics polled are planning to vote Trump.
I know. This is our challenge. And I'm going to tell you, there's work being done now. It's beginning to get to the people. That simply because a politician claims to be against abortion, which is intrinsically evil, no other considerations matter, and their character doesn't matter. And they've been able to use that. It still has power. Simply on the claim. Do you know that David Duke almost got elected governor in Louisiana? It was a few votes short. African-American people saved our hide because most whites and white Catholics voted for David Duke because he said he was against abortion. Look how this thing's been weaponized.
And we need to recognize this year in the United States, there have been 14 executions, and seven of them have been ordered by President Trump, carried out by William Barr, our Attorney General. Half the executions in the United States have been under federal authority. And before that, I think the last federal execution was 2003 or something like that. And there are a number of commentators who say that, you know, it's like sacrificing people to the gods of re-election, that President Trump needs to look tough, so rolls out 7, maybe even more before the year is over, 7 executions, and that gets him publicity. He appears to be tough on, you know, he's a law and order guy. Not law and order for taxes, but whatever. The law and order.
And look, the latest tweet with a COVID-19 infected president, and if you see, you can barely breathe. They showed it on YouTube that he can't breathe. And what are the 2 things he's tweeting out the most? Law and order and religious liberty.
Yeah.
Those are the 2 things he's still tweeting out with his COVID-19 infected fingers.
Well, there's nothing like executing 7 people. Half the executions in the United States this year. You know, like he's beating Texas to show that you're allegedly tough on crime, except not the crimes of the rich and powerful.
Well, I have to ask
Right, look at that expression on Brendon's face. Brendon, what you got to say about this?
So this is what I've been thinking for the last few minutes. You saw I don't hide my expressions too well, I guess.
No, you shouldn't.
Everything we're talking about here, as you said earlier, sister, is rooted in slavery. It's our nation's history. It comes down to the way we as a nation have treated Black people as commodities and property and less than human. And we do it today. Going from slavery to Jim Crow to the Black laws to separate equal to mass incarceration. You know, right now, the death penalty is state-sanctioned lynching. And that's what it is. And that's what we continue to do. And we have a president, a racist in chief, who is promoting this ideology throughout the nation. And it's getting traction. People are listening. People are voting based on race. So it is in some ways, a terrifying time. At the same time, there is this movement to really call out racism, but God, it is a fight. It is a fight. It is a fight right now. So that's what the look was for, sister.
Well, indeed. I mean, when we listen to the debate and we hear Trump saying that they're He doesn't see any evidence of systemic racism. You know, he doesn't think that the country has a problem with racism.
Stand by. Stand by is what he says.
People need to read this book if you haven't, The New Jim Crow. I've been reading it for the 4th time, and every page there's something new. And it's got more relevance to the year 2020 than it had for the year 2010 when Michelle Alexander first published this book. I mean, every page you go, wow, underline. You know, I don't like to ruin books by underlining, but you know, you can see I got my notes written.
Indeed.
So anyhow.
We do have some questions here. First of all, I have to say that LaWanda Lyons Pruitt, who is on my board of directors, says to Sister Helen, she says, "Amen, Sister Helen. We got to get Jesus right. Amen." Thank you, LaWanda, for that one. You know, a question here from Bo Keppel says, with relevance to racism and Christians, I strongly recommend the book White Too Long, from a quote with James Baldwin. It's by Robert Jones, the author of End of Christian American. So that's another question that came along here. Someone was asking for statistics on race issues as far as race of defendant, race of victim, asking for a source for that. Death Penalty Information Center on September 15th released a comprehensive study of race in the United States, and every piece of statistics that you would want, you could find there. And if you can't, just call Mike. As to, let's see. So I hope, Greg Wise, that answered your question. Other questions, what are the prospects of a federal Racial Justice Act if the Democrats take control? Does anyone have a perspective on that? And does the Democratic Party platform oppose the death penalty?
I know that in the last 4 or 5 cycles, the Democratic Party platform has opposed the death penalty. I don't know about this year.
And what do we think the likelihood is of a Racial Justice Act?
Well, you know, people were hopeful when Bill Clinton was elected president in 1992 that he'd do something on the death penalty. Quite the contrary, he felt the need to show that he was tough and all that. So his great claim to fame was ordering the execution of a guy named Ricky Rector in Arkansas who had tried to take his own life, and he had half a brain left. But Clinton nonetheless went through that. In the 1998 election, Michael Dukakis got slaughtered because of a guy named Willie Horton, a black guy who was furloughed and from prison and committed a rape while he was gone, while he was away from prison. And Dukakis arguably lost the presidential election because George Bush the elder was able to pin that release on him. Dukakis didn't have anything to do with it. But anyhow, Helen.
I do want us to note the hope of the waking up in this country. The best-selling books now on the bestseller list are all about Stamped from the Beginning, Kendi's book, the whole thing about racism and white people waking up. We've never seen so many white people out as part of protest. Maybe one of the gifts of COVID is everybody in their house, and they all saw the video of Darnella Frazier, that 17-year-old kid with her iPhone and her video camera that stood there and just videotaped the killing of George Floyd. Even though the guy, Chauvin, the police officer, was threatening to mace her, that kid took that video, and so many people were in their houses and watched it. And there's a saying from Latin America, what the eye doesn't see, the heart can't feel. And we are in a new moment of awakening in this country. And look at it. We have to ride with the waves and the currents of hope and help it to happen.
I have another question from the audience from Diane Wolf. She's asking, and this might be directed to you, Mike, how did the death penalty get outlawed in Colorado?
Well, it was a long struggle. The anti-death penalty movement in Colorado began in the late 70s. In the 80s, it was led by one lonely guy, a Jesuit priest, Jim Sutherland, who Helen knew well. He died about 10 years ago. And a small group of activists always kept that on the burner. There was one case where a man was executed in 1939, and in 2011, he got a posthumous pardon. False confession, a guy who was developmentally disabled, that added to it. But it was really just going out and putting up a table outside the church or temple and, talking to people. And the more, as Helen said, the more people know about the death penalty, the more likely they are to stand opposed to it. So there were researchers, academics involved doing the studies that needed to be done, showing that the worst of the worst were not those sentenced to death. The lawyers, led by a Boulder lawyer named David Wymore, world leaders in how to pick a jury, how to get a good jury, and also leadership among people in the state legislatures. So finally all came together earlier this year. It was a slam dunk, and we had 3 people on death row. Their sentences were commuted, and the homicide rate has not gone up. Who would have thought?
Well, and it was very interesting too. We had Beth McCann, who is the district attorney of Denver, on with Chesa Boudin a few months ago, talking about the death penalty and their experience for running to be district attorney and rejecting the death penalty wholeheartedly. And their comments were that it was very difficult and there was a lot of opposition to them. But in the end, they won. So there must be those citizens who support the notion, that the death penalty shouldn't exist. And as far as Beth goes, I know that she was a speaker to the legislature talking about why the death penalty should be eliminated. So some of this motion comes from politicians too. And I think that that's a good thing. So a few more questions from the audience. One question here that is, it's really a legitimate question, and it's from Dolores Shue. She says, how can a state hold a convicted man on death row for 20 or 30 years? She says that she writes to several offenders and they're stuck on death row. And the question is, why don't we just treat them as regular prisoners and move them to general population? Any thoughts on that, Helen?
Yeah. Did you speak to someone else, Nancy?
No, go.
No, the way we got the death penalty is that people were demonized and people were made to be afraid that the only thing we can do with these certain characters that are the worst of the worst is to terminate their lives so we can be safe. And you infuse the public with fear, and just always do remember that the death penalty, the executions are secret rituals. There have been 2 court cases, maybe both from California, try to make executions public, and that was refused. So the people don't see it. And so they're thought of to be the worst of the worst, so therefore they've got to be in a special place in the prison and with special guards, and all it comes out of the fear, out of the exaggerated fear that these people are so bad that that's what we have to do. The other thing is, and we got to start pursuing this, I'm going to start putting this out on our social media. The death penalty is torture. It is the UN Convention Against Torture, as the definition is, an extreme mental or physical assault on people rendered defenseless. What worse mental torture could you have than I got 3 days to live, 2 days to live? The people I've known, I've accompanied 6 people to death to execution. They all had the same nightmare. The guards are coming for me. It's my time. They're dragging me out, kicking and screaming, going, no. And then I wake up and look around. It was a dream. My time hasn't come yet, but it will come. Mental torture. The immediate anticipation that I'm going to be taken and killed. And physical torture. They now have 200 from autopsies of people who've been lethally injected. NPR just did this special study. It just came out last week. 200 autopsies showing that because of the infusion of the poisons put in people's blood, that their lungs are filled with fluid. They are drowning inside. But because of either the paralytic drug, which, renders them, they're just perfectly still, but they are drowning inside while they are being killed. And we got to start tackling torture. And again, we come to a Supreme Court at this point will not even acknowledge cruel punishment. It is torture of human beings. And we got to start addressing that.
I think going back to the issue of why do people not get moved into general population? In California, in the state of California, the guards who work on death row make more money than regular guards. They have a higher status in the system than regular guards. They have better retirement than regular guards. They get more days off than regular guards. And it goes on like that. And so the idea of these people in San Quentin is like, this is a career move for some of these, people who work in corrections there. And as we look to see when we did Prop 62 in 2016, some of the statistics that we developed through that were the statistics of the extreme cost of running San Quentin and running death row in San Quentin, which so far exceeds the cost of other prison facilities, even the highest level security facilities.
And Nancy, could I add a couple of points? One is that people complain about how long people are on death row. The other side of that coin is that if you go to the Death Penalty Information Center, they've got a list of the 173 people who have been released because of innocence after they've been exonerated. And some of those people have been there 15, 20, 25, 38 years before they're exonerated. So that also takes a lot of time. Another point that I wanted to make is that obviously the men on death row and few women who are there. There are 52 women on death row in the United States today, but they go through holy hell awaiting their execution. But I think it's even worse in many cases for their families. Could you imagine your kid is on death row? And the guy on death row has support from other prisoners, from lawyers, stuff like that. But the family sometimes, yeah. But the family is isolated. They live in the middle of nowhere. They don't know which end is up. I met one time a guy came to Florida with a gown, so that his girlfriend could be hanged in the gown. He didn't know what was going on. The guy's name was Pat, and he thought it was a she. But at any event, that's another story. But what these families go through, in many cases, I think that they suffer just as much, if not more, than the guy who's to be executed. And of course, after the execution, the inmate never suffers anymore, but the family does. They've got to live with that horrible experience and the stigma of having a loved one executed. Helen writes about this really well. She always writes really well, but in Dead Man Walking, about the families, what they have to go through and the stigma, and they don't even want to visit the prison for the last visit because they'll be spit on.
Well, a recent experience that I had was Chris Vialva. His mother, I have been on several Zoom meetings and so forth with his mother. Chris was 19 when he was arrested and convicted, sentenced to death for something he did at 19 years old. And he was a man with intellectual disability. And he was just executed September 24th. And his mother couldn't be there because of COVID. She couldn't be anywhere close to him. And the tragedy of that, the tragedy of having a son who was already at a disadvantage, who was biracial, who had, because of his disabilities and other things, been bullied his whole life. Seeing your poor son go through a terrible life like that and then never be able to get to say goodbye, I think must be just heart-wrenching.
You know what, I just have to say, I know a lot of times when people, if you're not engaged in the struggle, you just say, that's so sad. God, I hate to hear people saying that. It is more than sad. And we should be angry. We should be outraged over it. And that's a good part of the Bible, is prophetic outrage over injustice. And so or we can just get so paralyzed. It is so outrageous. It is so outrageous. And what does it take? And of course, my job, people who educate the public, it's to get people to get to a point. You catch on fire on this stuff. What are we going to do? You want to passively watch history and the atrocities, or you want to get into history and be a part of it? I'm reading John Lewis's life now, and religion, being ministers like Martin Luther King, the church really strengthened him and gave him community to fight. Well, we have to find the equivalent of that. If people, churchgoers have not been the ones, they've been the ones that have been the slowest to be angry over the death penalty and to embrace human rights. But we have to, what is the way that we get to the public and we get these stories so that people can have that fire, like that's wrong and I got to get in there and do something about it. George Floyd has really helped that. Black Lives Matter, all of that is a new moment for us, I think.
I need to return to the state of California because this is where I work, and we are looking forward to abolition in the state of California. And I wanted to ask you, Brendon, about your community and how your community stands on the death penalty, and how your community reacts to the reality of racism in the criminal justice system.
Interesting you say my community. I have lots of communities. So I'm going to take it from my public defender community, because I am the public defender. I think absolutely across the board, we are opposed to the death penalty. We praise Governor Newsom for his brave act with regards to the moratorium. And in his statement, when he did that, he addressed specifically how racist death penalty is and was, and how it's implemented. And you don't find too many leaders doing that today. So we really are thankful for that. But as public defenders across the board, we are opposed. We are in a moment right now where racial justice is at the forefront of everything we do. And it probably should have been at the forefront of everything we've done for the last 100 years, honestly. I think we're at a place where being a public defender isn't just a job, it's an identity. When you say community, we have a strong public defender community where we are putting our clients first, and clients are centered in everything we do. And so I'm fortunate to do this work. I love it. And I can't think of anything else I'd rather be doing right now. And when we talk about a movement, as we've seen from the Racial Justice Act, I think public defenders are somewhat central to that movement. It's public defenders and community working together to make sure that we create change. And public defenders are in a unique position to be close, to hear the stories of what's happening, to be in jails, listening to our clients, and being able to make sure that their voices are amplified. We're not saying our clients have voices, because they have voices. I mean, trust me, our clients have voices. It's just about making sure their voices are heard across communities, heard in our local courts, heard in Sacramento, making sure that their rights are protected and they're advocating to make sure change occurs. So I guess that's how my public defender community feels.
Thank you. It's great to, I have to say for myself, being a public defender is an honor. So I have a few more questions here. And I mean, one question for you, Brendon, too, is how will you be implementing the Racial Justice Act in your office? I think that's a great question.
Great question. It's so new, what we're going to see. And one of the things that was lost, unfortunately, in the Racial Justice Act was the retroactivity. That provision would have been great. I'm hoping that we can come back to that in some future year. But going forward, of course, coming towards the end of the year, probably January, I have a training about it office-wide, and then we'll start filing motions. It's going to be great. I think it's going to be tremendous. But it really is what I want to say or call a cure, or maybe a prophylactic, to prevent prosecutors from acting in racist ways. And it's an amazing tool we have now to say, when you do it, we can bring it to court forward and advocate for our clients around it. So.
That is great. A question for you, Sister Helen, too. Would public exposure to the actual executions reduce support for the death penalty, Or would public executions turn into a carnival of bloodlust?
We already have a silent carnival of bloodlust. What the eye does not see, the heart cannot feel. Why do we not make executions public? So as long as we're theorizing, we're picturing, oh yeah, well, that's going to make people, drink beer and celebrate. But picture this. Here's a little family in their living room and the evening news comes on. And part of the news is they're going to watch a man be killed. And you're going to see the warden, you're going to see the announcement, you can hear the last words, and you're going to see the person die. What happens in the hearts of the people? What happens in the hearts of the children who just says, well, mama, what are they doing? Is that a hospital? What are they doing, mama? And people see and people converse. When I came out of the execution chamber the night of watching Patrick Saunier be killed, electrocuted to death, it was a dark, I vomited, I threw up, and it was really clear in me, and it's never left me. The people, the American people, are good people. They just are separated from this and they're made to be afraid. My job is going to be a witness and bring them close. So then when they did the film A Dead Man Walking, they brought people over to both sides, the suffering of the victim, the whole thing. We got to bring people close. What the eye does not see, the heart cannot feel. And what you were saying, Brendon, lawyers being in there with their clients or witnesses, all the groups that work like for innocence, and Mike's work, sociologists that get the statistics that can sound very dry. Stalin said one time, if you kill one person, it's called murder, but if you kill a million, it's called a statistic. But to get those statistics and make them come alive, look at the pattern. The definition of intelligence is not to know trivial little facts of what year this war happened. It's to see patterns. That's real intelligence. So all of this works in this. But I believe the closer you bring the people, the quicker you end it. And I definitely believe that executions ought to be public.
I have a message here from Carolina Goodman asking, Carolina Goodman is with the League of Women Voters of Southern California, and she's in the anti-death penalty coalition that I'm a part of. And Carolyn asks, in recent years, California has tried to overturn the death penalty twice. How can we use Colorado strategies to be successful at the ballot next time?
Well, the first message is keep on trying. I mean, the last ballot initiative in California, was it 2 years ago?
It's 2016.
2016? Boy,
Yeah.
time flies. And the one before that was what year?
2012.
2012. So in between in those 4 years, there was really significant progress made toward abolition. I mean, the motion to abolish the death penalty was still defeated, but I think it got 51% of the vote, or 52%, much lower than it had ever before in history. California is kind of weird. The death penalty was put on the books by a referendum, and that means that only through a citizens' referendum can the death penalty be removed. Although clemency is another possibility, Governor Newsom, it's my understanding, and Brendon, you can correct me, that by his signature, he can remove half the people on death row. The other half who have prior felonies need the approval of the state Supreme Court. And the state Supreme Court is changing gradually. I saw today there's a new justice of the California Supreme Court. So clemency is one option, but it takes a ballot initiative to totally wipe it off the books.
That is true, and getting the ballot on the initiative, or getting the initiative on the ballot, has proven to be a very costly avenue. There is a legislative avenue where the legislators can vote to put the initiative on the ballot, and that's something that needs to be seriously discussed in the future, in the near future. So, a comment here from Martha Steinem says, we're suddenly realizing the white privilege we have taken for granted for too long. Black Lives Matter helps us realize how discrimination has been carried on without many of us being concerned. And that is certainly something that we need to keep in mind, isn't it?
Well, and it's not only white privilege. You know, certainly there's a lot of white privilege, but there's also white responsibility. I mean, white people who have, you know, the benefit of a college degree or the benefit of some economic resources, you know, that's carries with it a responsibility to get involved, educate. Maybe death penalty is not the thing for everybody, but there are a whole lot of issues out there that white people can use their privilege, their economic standing, and their voice to educate and move for social change.
You know what, I want to say that maybe when you say death penalty is not for everyone, I've discovered in the death penalty, all the 3 deepest wounds of America are in the death penalty. It's not just a peripheral moral issue about what you do with people who've done terrible crimes. All the 3 deepest wounds in America, that we have so many poor people and the free market and all the kind of stuff that we embrace continues for us to have 40 million poor people. We have never addressed equality of income and housing and the whole thing. Only poor people are selected for death. The other is race, which we've been talking about. Overwhelmingly, it's racist. But the 3rd deepest wound, and this goes back to the slaughter of Native Americans, to the bringing on of slaves, is that we feel deeply that we solve our social problems by bringing in the Marines, by doing violence, and that's the way you solve social problems. And the death penalty epitomizes that. So if you pick up, and by working on the death penalty, we are addressing 3 deepest wounds in America. And it's not peripheral issue at all, and it's for everybody, because if we tackle that, we're tackling everything.
Thank you so much for that. I'd like to ask each of you just to make a brief statement that gives us hope that we will address racism and that we will end the death penalty. So how about if I start with you, Mike?
Well, I remember in, I don't know, the late 90s, I spoke at an Amnesty International meeting in Scotland, and I went through 10 reasons to be optimistic about the end of the death penalty. And after that, people were coming up saying, "Are you kidding? I've never heard anybody optimistic about the end of the death penalty." My God, in 1998, there were 98 people executed in the United States. Public support for the death penalty was sky high. But there were signs even back then of the turnaround in death penalty opinion. Right now, if you ask people whether or not they support the death penalty, given the option of life without parole, only a minority support the death penalty. That was absolutely unthinkable. I remember being with Sister Helen in the late 80s. We were on the board of the National Coalition to Abolish the Death Penalty. And we were talking about who's going to pay the phone bill, basically. And somebody pointed out, well, if we get one athlete to speak out about the death penalty, we'd be in Fat City. Now, all sorts of athletes are speaking out about issues of racism in the criminal justice system. You know, in Florida, people like LeBron James, Michael Jordan, and other athletes have contributed a boatload of money to pay off the fines of convicted felons so that they can vote. So felony disenfranchisement, it's coming around. So I'm a big believer in persistence. If we, just keep on trucking, the worst thing we can do is ignore it. And then that's the only way the death penalty will continue.
Brendon?
Yeah, I'll be honest. Sometimes I struggle with hope. Doing this job and seeing the horrors of our criminal punishment system every day, fighting the fight, but sometimes hope is hard to come by. I think there are 2 things that give me hope right now. One is the resistance that we're seeing across the nation to racism. And I think you see it on both fronts. We feel like in some ways the racist forces a la Trump are in power and have some sort of strength, but there's a reaction to, I think, the movement that is happening with Black Lives Matter. I think we are getting ahead and winning, and this is kind of the last gasp of racist institutions. And I think my final thing that gives me hope, this is going to sound really silly, but TikTok. The youth. Their means of communication, their means of social media, and the way they are on point with messaging at lightning speed. And they seem to relate so much better to our cause and our movement and what we're doing than previous generations. So I think the youth gives me a lot of hope. A lot of hope.
Thank you for that. Sister Helen?
Just briefly, before when I wasn't acting and I was standing on the sidelines and just praying that God would help all these poor people, I didn't even know what hope. I hoped it was a wishy kind of God do something. But boy, the minute I started putting my hand on a rope and starting to pull and got involved, life flowed through me and I experienced hope. Hope is an actualized feeling when we get involved, not when we're standing. And the more information we get in by with our iPhones and Google and are not acting, the more paralyzed we get. The simplest action. And the hope is in our room today, our virtual room with all of us hearing this, all of us sharing this, and that little gleam of fire. And then you leave this room, this virtual room, and we put our hands and we continue what we're doing. That's hope alive. That's real hope.
Thank you. Thank you. Thank you all so much. This was just wonderful, a wonderful conversation. And just having you here gives me hope. So thank you. Thank you so much to the audience. We'll be back on shortly next week with the death penalty and closure. I do hope you'll join us, and please contribute to Death Penalty Focus. Thank you.
Thank you.
To all of you, we'll talk soon. Thank you.